Hi, good morning, everyone. This is Rajiv S. Khanna for immigration.com, law offices of Rajiv S. Khanna PC. Couple of comments on my blog. I had recorded a video, actually a screencast, about what people should do who are applying for H-1 visas. And one of the interesting questions from our community member at forums at immigration.com from Ram_C. He says right here, Khanna, do you suggest full-time employees to go for H-1B stamping to Hyderabad consulate at this point of time? Well, my advice, folks, is this. First of all, when you say full-time employees, I would like to point out a couple of things there. I think what you mean is you're making a distinction between somebody, an employee who works at a client site, and an employee who works in-house for the company that processed the H-1. So if you mean full-time in the latter sense, then I would say they have the strongest case usually. But don't be fooled. I have seen consulates come up with the strangest requests, prove that you have a project in-house. Oftentimes it's very difficult to prove a discrete project because what you are working on may be a part of several different projects. So don't be fooled. My advice is if you can avoid going for H-1 visa stamping altogether, that is the best thing to do. The comment before that, if you look at my blog entry, and this entry is in my blogs under H-1 visa affidavit in Hyderabad. One comment was that the advice that I have given is helpful. Well, and my response was it's that the government has gone from strict to illegal, and that is just absolutely true. Many of the things the consulates have done, they incense me as a practitioner, as somebody who has always believed that the laws should be administered even-handedly and according to the book. The government itself is guilty of breaking laws in my view, extremely flagrantly. They get away with it simply because, number one, we cannot file a lawsuit against the State Department acting through its consulates because they have a kind of an immunity from lawsuits. It's called the doctrine of consular non-reviewability, which basically means whatever the consulate does is pretty much okay, and it's very difficult for courts to look at it. Partly that, and partly because I feel that there is very poor supervision of individual consulate actions. So we've had so many cases where a visa was approved 8, 10, 12 months into the process. We were retained by various people to try to do something about it, and finally these things are solved. But which client is going to, or which employer is going to wait 9 months for an employee to show up? Does that happen in the real world? No. So bottom line advice is if you can avoid going for stamping, avoid it. Where if you are an in-house employee, even then don't be sure that it's going to work out. If you are working at a client site, chances are slim that you will get a visa stamping. So far this is what is going on. Okay, I hope to talk with you guys soon.